You hear a lot of people claim that the U.S. Constitution doesn't include the phrase separation of church and state. While that's technically correct, it's also completely irrelevant. The Constitution also doesn't say anything about capital murder. That doesn't imply that it's legal. Fortunately, the justices in the U.S. court system have a little more knowledge of both the letter and spirit of the law. The principle of separation of church and state is found directly in the Constitution in Section 3, Article 6. No religious test shall ever be required as a qualification to any public office or public trust under the United States. The interesting thing here is that in the original Constitution, we're talking prior to the Bill of Rights, that is the sole reference to religion. And that reference was to deny religion any part in the process of determining qualification for public office. Basically, for all intents and purposes, religion was barred from having anything to do with government at that point. Of course, Founding Fathers were also painfully aware that issues between religions had fueled hatred, repression, and even bloody civil wars in Europe. One example of that is the 30 Years' War. This was wholesale butchery based upon religious lines, and it had happened not long before our Founding Fathers considered the Constitution. It was as fresh in their minds as the U.S. Civil War is to us. We all know that many of the early colonists had been motivated to come to the colonies to avoid religious persecution and religious intolerance. When it came time to build a new nation, a lot of those early colonists were determined that such government-sanctioned intolerance was not going to be part of this new nation. Thinking about it, this was a radical move. At the time that phrase was ratified by the states, it was unprecedented among developed nations of the time. For centuries, some form of a religious belief had always been a prerequisite for holding public office in most European countries. The Founding Fathers had based much of their thinking around the philosophy of John Locke, but even he hadn't been so radical as to promote such an idea. This was a major leap forward, and it was something unique to the new American nation. As any study of the history of the early colonies shows, the Constitutional Convention was not the first time that Americans had implemented laws against religious repression. As far back as the Flushing Remonstrance of 130 years earlier, colonists had organized to resist against government intrusion into religion. Many of the Founding Fathers were products of the Age of Reason, but even the colonies had already experienced some problems with government interference in religion. One example was a Pennsylvania law that only allowed Protestants to hold office, which was ironic given the fact that a great many Revolutionary War soldiers had been Catholic. Even prior to the Constitutional Convention, a number of states had already enacted laws that forbid government meddling in religion. One example, New York had already included it in their state constitution. In Virginia, in the meantime, the arguments against government intrusion into religion had gone much further. In Thomas Jefferson's Virginia Statute for Religious Freedom, he wrote about the freedom of conscience and about the principles of separation of church and state. The Virginia Statute is considered by many historians to have had a great influence among the Constitutional Convention at the time. Another example was James Madison's Memorial and Remonstrance Against Religious Assessments of 1785. In Virginia at the time, a law had been proposed that would fund religious instruction from Commonwealth funds. In a lengthy and detailed diatribe against the proposed law, Madison destroyed the idea of government entanglement in religion. Written shortly before the Constitutional Convention, Madison's Remonstrance also had a major influence on the framers of the Constitution. So the idea of separation of church and state was not a new idea when it was discussed and debated at the Constitutional Convention. As you read through the historical record of the time, at times the discussion appears almost comical. We always like to think of our Founding Fathers as being motivated solely by the principles of the Enlightenment, but there were a lot of entrenched parochial interests that took part in the debates as well. Religious denominations of the period were concerned about their relative influence in the political process. Congregationalists didn't want the Church of England to be dominant. Church of England didn't want the Quakers. Quakers didn't want the Baptists. And of course, nobody wanted the Catholics. As a result, they all agreed, however reluctantly, that nobody was to have special privileges in the new government. So, ironically, one of the main reasons we have separation of church and state today was because of mutual distrust between Christian denominations of the time. During the Constitutional Convention, the delegates were determined that the new nation would be inclusive to all, not exclusive to one preferred class or faith. It only makes sense. The U.S. had railed against things like royalty, privilege, class consciousness of Europeans, so it only made sense to oppose the same kind of religious repression that Europe had known. One thing that's important to realize here is that the separation of church and state is not anti-Christian. It's not anti-theist. It's not anti-religion in any way. Very much the contrary. Separation of church and state prevents a tyranny of the majority type of mob rule when it comes to religion and government. Interreligious strife had been a serious problem for Europeans, and our founding fathers were determined that it would not become an American problem.
This land is your land, and this land is my land, from the California to the New York Island, from the Redwood Forest to the Gulf Stream waters. This land was made for you and me.